Compensation Court of Appeals is now in session. The Honorable Sean M. Quinn presiding.
Good morning, everyone. Please have a seat. All right, we have one case for oral argument this morning. File number WC 236527, Lucas Peterson versus the City of Minneapolis. Today you have the pleasure of having all five of us. Chief Judge Millen, Judge Sundquist, Judge Christensen, and Judge Carlson, as well as myself. I assume you both know the rules, but I'm going to give you a reminder anyway. You each have 15 minutes for your respective arguments, and the burden is on you to keep track of time on the clock. When your time expires, we may have additional questions, so just keep talking and we'll keep getting answers. When your time is up and there's no more questions, then you can have a seat. Appellant counsel, Mr. Gabor, you have whatever time you have left over, if any, for rebuttal. You don't have to tell us you want to reserve rebuttal. You have it if you have it. If you get it all used up in this time, such is life. Also, we're recording this and live streaming this. The acoustics in this room are not particularly good, especially for the people behind you. So you have to use your outside voices, or what I call my normal everyday voice. So anyway, Mr. Gabor, go ahead.
Good morning, Ms. Bierman, Mr. Peterson. May it please the court. As you indicated, Judge, my name is Anthony Gabor. I'm an attorney representing the City of Minneapolis this morning in this case. And we are here today appealing a decision of the Workers' Comp Court in this matter. And there are three main issues.
Clock hasn't started.
I'm so sorry.
That's okay.
Would you like me to start again?
Yeah, you got extra minutes or extra seconds.
All right. As I indicated, I'm here today representing the City of Minneapolis in this case that we've appealed from the Workers' Comp Court. And there are three primary issues that I wanted to talk about today. And the first one is did the workers' compensation judge make an error as a matter of law when he held that the Hers versus Mower County Supreme Court case of 2023 was distinguishable from this case and did not apply, because in this case the employee's expert opined that regardless of the fact that there were no changes in the most recent version of the DSM-5TR, that the employee qualifies now for this alleged diagnosis of PTSD lifetime. The next issue for consideration is, did the compensation judge commit a legal error when he imposed penalties on the City of Minneapolis for asserting a frivolous defense in this case, specifically whether or not the employee had a personal pre-existing mental health condition. And finally, did the compensation judge commit an error of law relying upon the opinions of non-psychologists and psychiatrists in making his decision in favor of the employee? Now, with respect to the very first issue, this case is extremely similar, fact-wise, to the Hers case. As this court recalls, in Hers, there was an initial diagnosis by the employee's expert, Dr. Nicole Slavic, of PTSD. Subsequently, Mr. Hers was examined by an expert from Mower County, or hired by Mower County, Dr. Paul Arbisi. Dr. Arbisi found in October of 2020. Yes?
I'm going to interrupt you.
Of course.
The difference between Hers and this case, to me, is that there's a new version of the DSMs between the two cases. Would you agree with that?
There is a text revision to the DSM-5.
Right.
Yes.
So my question for you is 176.011 subdivision 15D, I believe, says that we have to look at the, when I say we, whoever is looking at it, needs to look at the most recent version of the DSMs. So my question for you is, at what point do you look at the DSM? Is it at the date of injury, the date of diagnosis, the date the compensation judge is looking at it? At what point do you say, let's make sure we have the most recent version?
Well, in this case, Your Honor, I think it was Dr. Alec Novichess testified that the most recent version came out in March of 2022. So to answer your question, I would say that any cases that come on or after, and I don't have the exact date, but it was March of 2022, on or after that date, that's when the court and the experts need to look at the most recent version.
Well, I compliment you for saying her full name. I'm not really do that.
I think that's the first time I did it right.
Dr. A.
That's what we call her most of the time too.
When you say the cases that come on after that, but what do you mean? The date of the initial diagnosis, the date that the expert is looking at it, the date the compensation judge looks at it? Because clearly, in this case, there was a date of injury, there was a new revision, and then, of course, there was the hearing.
Yes.
Is the compensation judge required to look at the version that is most recent to that decision?
I would say, Judge, that any exams that are completed on or after the new revision comes out should, because at that point, the expert should be looking at the new revision. So I would say that any examinations that are done on or after the date of the new revision should reference and use the new revision. So in this case, that would be March of 2022.
So was it appropriate then for Dr. A, in her live testimony, to refer to the new revision, and was it appropriate then for the judge to consider the newest revisions?
It was, because the hearing was last April, March and April of 2023. So it was. I would indicate that the criteria in both editions, the DSM-5 and the DSM-5-TR, did not change. They are, and that's undisputed. They're word for word the same, the diagnostic criteria. I referenced a moment ago that there was a text revision made, and there was a revision, there was an addition of a paragraph in the notes and in the commentary that follow the diagnostic criteria. But the criteria themselves did not change, not one word.
All right, so
And
here's the question I have for you though, Mr. Gabor. And when the Supreme Court issued its decision in Smith v. Carver County, which goes back more years, they specifically said you have to leave the reading of the DSM to the experts. And they chastised this court for daring to read it. And I'm going to let you on a little secret. I got it right here. I looked at it. I even put Post-it notes on it. So I know exactly what you're
Keep that
talking about.
between us,
But
Judge.
I didn't, but the Supreme Court's not going to watch this, so they won't know that I read this. But if we're not supposed to read that and we have to leave it to the experts, Dr. A says lifetime PTSD is a diagnosis. Dr. Young says, no, it's not. The judge picked one over the other. He didn't look to the book to decide whether the book meant the one thing or the other. He left it to the experts, and he had to pick one. He had to pick one. I don't even know which one's right. I think both parties make good arguments on that issue. What are we supposed to do? Can we look at this?
Well, unfortunately, the Supreme Court has ruled that you cannot, okay?
Right.
And we can agree or disagree with the Supreme Court on that, but that's what the Supreme Court has said. Okay, so that said, if we look at what the experts said, what you are allowed to do and what the workers' comp judges are allowed to do is to take a look at the reasoning and the foundation of the opinions of the experts, okay? And the judge in this case made his decision. However, you are also able to review this and see if that decision was well-founded and based on substantial evidence, okay? And if we take a look at the opinions, okay, Dr. Young, who was the city of Minneapolis' expert, when asked about this, said this PTSD lifetime is not a diagnosis. It's a discussion point for whether or not somebody has ever met the full criteria for PTSD in their lifetime. That's where that word lifetime comes in. Okay, because what the criteria, and both experts talked about this, so it's in the record. You don't have to look at the DSM-5 TR to look at this. What we're looking at is criteria F, okay? And criteria F, like I said, along with the other criteria, did not change from the DSM-5 to the DSM-5 TR. TR stands for text revision, okay? Criteria F says you must meet all of the criteria, A, B, C, D, and E, for at least 1 month period of time, okay? And that's what it says. Now, the revision just went on to clarify that for a current diagnosis, meaning one today, you look to see if the individual has met all of that criteria for the past month. So from the date of examination back 30 days, okay? What they were clarifying, and I will submit to you, and I know we're not looking at the DSM-5 TR here, what they were clarifying inartfully, in my opinion, okay, is that for a, quote, lifetime diagnosis, you must meet all of that criteria for a period of 1 month at some point in time, okay? So in some point in your lifetime. And the reason Dr. Aleknoviches opined the way she did is she was basing her opinion on Dr. Cronin, who was the original psychologist who diagnosed Mr. Peterson with PTSD back in June of 2021. Because recall, when she examined Mr. Peterson, she didn't diagnose him with PTSD. She diagnosed him with something called other specified trauma-related disorder, and she referred to it as subthreshold PTSD. Yes.
Before we kind of walk down that alley, I want to stick with the PTSD diagnosis. And I follow what you're saying, that a lifetime diagnosis of PTSD might not be, I mean, it's a permanent condition. It just means in your lifetime. So, but even if that is the case, isn't that enough to have the diagnosis of PTSD? Right? The statute doesn't say it has to be current. It just says there has to be a PTSD diagnosis.
Well, if we take a look at the Hers case, okay, the whole reason, the ruling in the Hers case said when you no longer have the diagnosis of PTSD, you're no longer entitled to benefits.
And sorry for interrupting again, but again, isn't a lifetime diagnosis of doesn't that diagnosis still stand? Doesn't the TR give some legs to that diagnosis? If you have a lifetime diagnosis of PTSD, you still have the diagnosis, right?
No, Judge, because what both experts agree upon is that with treatment and time, people get better. Dr. Young indicated PTSD is not permanent, okay? And Dr. Aleknoviches didn't testify otherwise. In fact, they both talked about the fact that with treatment, they would expect symptoms to get better. And in fact, in her report, where she didn't diagnose PTSD, at the very top, she says, look, it looks like he's had long-lasting treatment and medication, and the severity of his symptoms have been reduced.
And that's good. That's what we want. So doesn't and I'm sure you read it. One of the things that really bothered me in the Hers decision, and I wrote a dissent, was the employee is no longer entitled to get treatment, at least paid for by the employer and the work comp insurer, if one little part gets better and they don't meet the PTSD diagnosis criteria at the moment. But if we have the lifetime diagnosis, kind of like alcoholism, like Dr. Young testified to, then they can still get the care and not fall off the edge or have a triggering of moment where the employee gets full-blown PTSD. Isn't that, from a public policy perspective, and I know we're not supposed to deal with that, but from a public policy perspective, don't we want employees to get that care?
We do, but as was also indicated in the Hers case, Judge, is that, and I would draw the parallel, if the workers' comp court decision is adopted, then what you're doing is you're making this diagnosis perpetual. Okay, and I'm paraphrasing the language in hers.
I remember that.
Yeah, and the HERS court says that this is not a perpetual condition. And you're right, we do want people to get better. If you draw an analogy to physical injuries, primarily where if someone is physically injured on the job, they get treatment, but at a certain point, they've reached MMI, and they're as good as they're going to get. And then there's,
Stop getting care, though.
I'm sorry?
After one reaches MMI, it doesn't mean they're not entitled to medical care anymore.
That's true, but at some point, the medical care is no longer related to the disability per se. And I think that's the analogy here, is at some point, the care is no longer related to the disability. And as this panel knows, the statute has defined what a mental impairment is and what an occupational disease is. And HERS sort of said, listen, this statute says you are entitled to benefits for PTSD and no other mental health condition.
So, counsel, why do you think that the legislature put PTSD under an occupational disease as opposed to a specific one? Does mental illness really fit into the matrix system of a broken back, of an amputation of a finger?
Well, I wish I could divine what the legislature was thinking.
I don't mean to be flippant. There were a lot of discussions. There was testimony. There were experts. It went through different councils. This is serious. We can talk about legislative intent. A lot of these people really work hard as public servants to get it right. Why do you think it was put under the occupational disease as opposed to a specific? Because it was heavily lobbied.
Well, I think if you read that section of the statute in its entirety, it doesn't apply to everyone. It applies to a certain segment of our society, law enforcement, firefighters, first responders. So I think, it's not as broadly applied as most of the workers' comp statute in terms of just general employees. It applies only to a certain segment of the society and certain professions. And so I think it's something that, the legislature, like you said, it was heavily lobbied, but the legislature determined that these particular professions were, more likely to encounter this type of the trauma that is necessary for you to meet what we all know now as criteria A of PTSD. So I think that's why, at least, again, I'm trying to divine the legislature's intent, but I think they tried to narrowly tailor it and make it as specific and as detailed as they could.
Mr. Gore, I do have a question. I realize that your time is up, but I'm sure we all have additional questions. My question concerns basically weighing one expert's opinion against another's, and in this case, Dr. Young versus Dr. A. And I would like you to address how we should look at this. I mean, we're looking at two expert opinions. The judge has the choice between the two, and we typically have to uphold that choice. And in this case, you chose Dr. A. Were there foundation objections to Dr. A's opinion on the TR version at the time of trial? I believe there were.
There were.
And I'd like you to address the foundational issue here, because basically that's really the only out that I see for you with regard to the two experts. So if you could comment on that, please.
Yes. The simplest way I can describe it is if you agree with the workers' compensation judge and adopt Dr. A's decision, what you're really doing is you're legally turning psychology on its head by basically saying PTSD is permanent. Once you have a diagnosis, you always have PTSD. No matter what kind of care or treatment you get, that diagnosis follows you the rest of your life. That's just not what the professionals say. That's not, this would, put a lot of psychologists out of business, because no matter what type of treatment you offer, no matter what you do, this person carries PTSD for the rest of their life. That's just not how it works in the mental health profession. And it's not what Dr. A opined in her first opinion. I mean, she indicated that, yeah, he probably had PTSD at some point based on Dr. Cronin's opinion, but the symptoms have now reduced. And she herself, when she was talking about this other condition, she gave examples, and by that I mean the other specified trauma-related disorder. She gave examples of when someone can diagnose a person with that condition, 3 in fact. And in the record, one of them was in a situation just like this, where somebody had been diagnosed with PTSD, they sought treatment, they were on medication, they got better. They still might have some of the PTSD symptoms, but not to the severity. And I'm sure you read the record. There are ways that the psychologists test for this, and they talk about frequency and intensity of the symptoms to come up with a severity score. I'm getting a little deep in the weeds, but I'm just trying to give you an example of how this is diagnosed. And what Dr. A said is because of the treatment and medication, the severity, and that's made up of frequency and intensity, got better, and the severity was reduced, so he no longer meets the full criteria.
You're right, and I understand her original opinion was that he did not meet the criteria under the DSM-5. My question is, does Dr. A have the necessary foundation to then change her opinion to, yes, now he does have this lifetime PTSD diagnosis?
In my opinion, she does not.
And tell me
Judge.
why.
Because, like I said, the diagnostic criteria did not change. There was just a clarification as to when in a person's lifetime you could determine, okay, in June of 2021, according to Dr. Cronin, he had PTSD. He met all the criteria for PTSD. But in March of 2022, according to Dr. Young, he no longer met the full criteria, specifically C and D. In May of 2022, according to Dr. Alec Noviches, he also didn't meet the full criteria. She found he didn't meet D and E. And both experts testified that you must meet all of the criteria for a
I
diagnosis.
think you're giving yourself some legal arguments that you don't give to the other side here. If you can move into PTSD and then move out, and under your theory, you consistently move so that you don't meet the criteria, you can also move back in again, and it can wax and wane, correct?
Potentially. But
Potentially. So are you ever really done? Or is it in fact a lifetime diagnosis that you meet it in 2012, but you don't meet it in 2013? And I'm just pulling dates out of the air here.
well, that's a hypothetical. And to that, I would just say, when Dr. A rendered her opinion at trial, it's important to note she had not examined Mr. Peterson again. Okay, the one and only time she examined him was in May of 2022. So she rendered this opinion for the first time without any written support at the hearing, and basically said, yes, he would have met the criteria for PTSD. She didn't examine him again. She didn't talk to him again. She didn't, and when you talk about foundation, the statute talks about the person must be diagnosed, okay? And Juntonin has talked about what diagnosis means. An examination of the symptoms. You examine the person, okay? So what I would argue that in this case, what Dr. A did was not a diagnosis. She never examined him again. So when you talk about foundation, I think that needs to be considered. There was no second examination. And I know I'm way over my time. I would just point out, and this goes to foundation and credibility, and this is in the record as well. Dr. A's entire forensic practice, okay, is dependent upon the respondent's attorney and her law firm. So I think that should be noted for the record, and that should be considered with respect to foundation as well.
So you find her, excuse me, help me out here. What are you saying?
I'm saying that
There's a bias?
when you look at
No,
foundation,
just tell me, is there a bias?
there certainly could be, Your Honor.
There could be, but are you making the statement here that she lacks credibility or the weight of the evidence should be such based on the professional relationship she has? I mean, are you making that statement here?
I'm saying
Are
that
you
it's
just trying
something
to-
you should consider.
I should
Judge,
consider based on what evidence?
based on the evidence that Dr. A testified that all of her forensic work, all of it, is comes through the respondent's attorney in her law firm.
And that sense, that makes her less credible in your eyes, but not in the compensation judges, correct?
Well,
Correct?
I can't, I don't know what the compensation judge was thinking, Judge.
Well, I'm thinking he accepted the weight of the evidence as Judge Sundquist did and made an opinion based on weighing the evidence of two experts. And that he had that information before him at the time of the hearing,
He did.
correct?
He did.
So the judges committed an error of law? Or,
Well, he committed
no,
an error.
but to this issue? Or did he just not do his job to a certain level of substantial evidence? I mean, what are you saying here? Is there an abuse of his discretion?
I'm saying that this is an issue that you're able to take into consideration. Obviously, it was in front of the workers' comp judge as well. He made his decision, and that's why we're here today, because the city of Minneapolis believes he made the wrong decision.
All right,
Mr. Gabor, I'd like to change issues here because we never did reach the penalties claim.
before we get to that,
Yes,
can
go
I?
ahead.
So let's assume that we agree with you entirely. So now, there is no such thing as PTSD lifetime. Judge made an error of law. Dr. A also opined that this other trauma diagnosis was a consequence of the PTSD. And that was one of the issues before the judge. Is there a consequential injury? He didn't rule on it. Are you asking us to remand it then to decide that? Because that still would have to be decided then, correct?
Well, Judge, I would say that issue's not before you. That issue wasn't appealed. He didn't make a ruling on it. So I don't know that this court needs to address it.
Well, I don't think we can address it without a finding, but there's an issue that's raised by the judge. It's not decided. There is actually a statute that says compensation judges are to decide all issues before them. They never do, if they can avoid it. But if we say you're right, the consequential injury still is lingering out there. The HERS decision said we're not deciding whether consequential injuries from PTSD are covered or not. We're leaving that up there still. So that's an open issue, but wouldn't we have to remand then? And you're saying no.
I would say that because he made well, I suppose you could, Your Honor, and I guess if you want me to address consequential injury, I can.
I just want to know if you think is that the remedy if we agree with you? Or is it just reversal?
I believe it's just reversal because consequential injury is not before you. And if, like I said, if you want me to address it, I can, but I don't believe it's properly before you, and it's not
Okay.
an
All
issue.
right. And I understand your answer. Okay. Judge Sundquist.
Yeah, I just wanted you to address the penalties issue. That was your second issue. I just like to hear what you have to say about that.
Yeah, and I addressed it briefly in our brief, but basically, if you look at what the statute talks about, it talks about assertion of a frivolous defense, and that's what the judge found. And the definition of a frivolous defense is if there's no basis in the fact or law on it. And as I indicated, when the city of Minneapolis first got this case, they had Dr. Cronin's opinion only. And in Dr. Cronin's opinion, he does mention that Mr. Peterson sought treatment sometime in the 2002 to 2004 range, mental health treatment, okay? And what the judge at the workers' comp court said was there was no evidence of prior mental illness or treatment. And I think that's incorrect because all we know is from Dr. Cronin at the time the city got the case was he was treated in the early 2000s by a gentleman named Dennis Conroy. So there is evidence of prior treatment. And at that point, we don't know what for how long, or anything like that. So it's to assert that he potentially had a prior mental health issue is valid. And I don't think a penalty was the proper remedy there because at that point we haven't, all we know is what's in Dr. Cronin's report. And
All right.
so,
Well, but Dr. Cronin's report says, as you said, prior care with this doctor, and Dr. Cronin goes on to say, a doctor who's familiar with law enforcement or does a lot of care for people in law enforcement. And then there's a list of all of these horrific events that the employee underwent starting in 2002 at work. And there's one in 2002 and one in 2004, and then there's a gap in time. I mean, reasonably, we can conclude from that it was work-related trauma. But maybe there's something else. But what I don't see is anything else proffering a defense saying there was a pre-existing thing ever. And in fact, the next defense was, here's Dr. Young's report. So, I mean, at no point was the notice of primary liability determination amended with, yeah, we looked into it, it's not covered, the presumption applies, we're going to start paying benefits until we get a report. I mean, the city didn't do anything for a fairly long period of time, like a year. So I think that is more troubling than just the denial all by itself.
Well, first to the point of what Dr. Cronin's report goes on to say. You're right, it does go on to say that he's well-versed in dealing with law enforcement. That doesn't necessarily tell us, though, that what he saw Mr. Peterson for was work-related. It just says this is a gentleman who's worked with law enforcement, so we don't know yet.
Right, so you don't know, and so you're saying in the denial, and I know you're not saying it, but your client is saying, we have to investigate that. Then where's the investigation? It's not there.
Well, the investigation then is once the claim petition is filed, then we go ahead and get medical records, we get authorizations, and we get medical records. And then, as you indicated, Judge, that's not a defense that we then pursued. That there's no further, and you're right, the primary liability answer was not amended, but it was not a defense that we pursued or argued at any point in the litigation. So it's not something that was material to the case. Because
so doesn't that make it just, it may not rise to the level of frivolous, but it wasn't a defense. And the NOLPD was never amended to say, no, we're taking that out. We're going to base it on Dr. Young's report. That's kind of troubling to me for reading the record and the injuries claimed by Mr. Peterson in this case, because there's various traumas that are part of this, and I think to have his employer say, oh, there's some pre-existing, and then never come up with anything that says, yeah, there's pre-existing, or say, no, we looked at it, it was wrong. That's troubling to me. Can you explain to me why that doesn't rise to a level of penalties, even though there may be, it's simply because you didn't pursue it and nothing was ever done.
Right, and that's because, like you said, we determined it wasn't a material defense. And if it was just a matter of amending the primary liability issue, I mean, that is something that can be easily corrected. But I would assert that it's not a frivolous defense based on what the city knew at the time it made the denial. And it never pursued that defense because it just wasn't material and it wasn't part of the case.
But what did the city know? Other than Dr. Cronin saying there was some pre-existing care 20 years before, and the notice of and Dr. Cronin's report says 20 years before he was subject to work-related trauma. I mean,
I don't know that Dr. Cronin comes out and says that directly. I think you're right, Judge. He makes the statement he makes about the prior treatment in Dennis Conroy, and then in his report, he goes on as part of his examination to set forth the trauma that Mr. Peterson suffered. He doesn't go into any detail about what Dennis Conroy treated him for. So your point is well taken, Judge. It's just that we don't know what we don't know at that point.
right, and I think that's probably what troubled the compensation judges. You know, the city can always admit a claim and then say, you know what, mistake of fact, we're going to deny the claim or change in something. Instead, the city said, well, we might have a defense, so we're denying it. And that's pretty much all it is we might have a defense.
And Mr. Gabor, you indicated that the the reasons listed on the NOPLD to deny the claim were not pursued as material defenses after that. But at any point before, or at any point, did your client then admit liability for the PTSD and pay any benefits?
We did not, and that was based on Dr. Young's report.
All right. Any other questions from anyone? Okay. Thank you, Mr. McGuire. That was really very enlightening and very good. So,
Thank you.
Ms. Bierman.
Good morning. May it please the court. My name is Ashley Bierman, and I represent the respondent, Mr. Peterson, in this matter. Mr. Peterson is in the courtroom with me today. Before his PTSD injury, Mr. Peterson was a highly decorated police officer for the city of Minneapolis. He served the city of Minneapolis for more than 2 decades. As a police officer, as you'll see in the record, he experienced many large-scale traumas. These traumas were extreme in nature. And this is largely because that Mr. Peterson served in units within the Minneapolis Police Department that were much more proactive. For example, he served 18 years on the Minneapolis SWAT team. As a result of experiencing these many traumas through his service as a Minneapolis police officer, Mr. Peterson's mental health deteriorated. Mr. Peterson was diagnosed with PTSD by not one, but 2 licensed psychologists. He was also diagnosed by a board-certified psychiatrist. He was also diagnosed by his treating providers, his primary care doctor, Dr. Dahlstrom, and his therapist, Nick Widener. Mr. Peterson continued to be impaired from his PTSD through the date of his evaluation with Dr. Alec Novichus, and per the compensation judge's finding, through the 2nd day of the hearing. He continues to have work restrictions.
Ms. Bierman, I'll just cut you off so we can kind of dig into it.
Absolutely.
So this conversation about the diagnosis of PTSD and the discussion of the most recent version, and the most recent version being the TR that talks about current versus lifetime PTSD. Is it your argument that lifetime means permanent? There's a permanent diagnosis of PTSD, or is lifetime qualifying like a lifetime diagnosis of pneumonia, or lifetime diagnosis of, perhaps a recurring type of condition?
Thank you, Judge. It is not our argument that a lifetime diagnosis of PTSD first is a separate diagnosis at all. The diagnosis here is PTSD. What we're looking at it's underneath the DSM-5 TR, and we're looking at the diagnostic features section, which explain each of the criteria that are set forth in the DSM. In the section regarding criteria F, changes were made, and there is reference now to what's called a lifetime diagnosis, but the diagnosis remains PTSD. And furthermore, that does not mean that this PTSD is going to be permanent, because all of the criteria of PTSD still apply here. So for example, if you look at the DSM-5 TR, there's criteria A, which is the threshold issue. Did this person experience a trauma that meets that criteria A definition? And that's going to remain stagnant throughout this claim. Then we look at criteria B, C, D, and E, which are symptom clusters, the different symptoms that folks are experiencing when they have PTSD. And then criteria F says that this disturbance must last a period of 30 days or more. So what we're looking at here is B, C, D, and E. Those symptoms have to.
Right, and so I understand what you're saying, but in reading the criterion F under the TR, once you qualified for current PTSD, you would then necessarily qualify for lifetime PTSD. And what is difficult for me is I think once you then get a PTSD diagnosis, you will necessarily have a lifetime diagnosis of PTSD. And do you think that's what the legislature meant? Do you think that that is what 176011 sub 15 was meant to cover people for PTSD for their life?
I'm going to answer the first part of that question first. It would not result in a perpetual diagnosis. And the reason for that is you still have to meet all the rest of the criteria. So after criteria F, there's criteria G. And what criteria G indicates is that the symptoms, so those clusters B through E, have to be of such a level, such a severity, that they're either causing clinically significant distress or impairment in one or more important areas of life. And the DSM specifically defines that for us. That can be vocational impairment, that can be social impairment, that can be other areas of functioning. And Dr. Alek-Novichess in her testimony said that can be things like parenting, things like if you're going back to school, having difficulty in school, it has to be impairment. So this isn't perpetual because along with this initial period of 30 days where you meet all the criteria, a person still has to have impairment. If there's no impairment, there's no ongoing benefits because there's no PTSD diagnosis.
So would a better diagnosis be at some point in time, and having looked at the TR version, would be something along the line of PTSD, that's the diagnosis, in remission or something along that line? Is that what you're saying? Because as I read Dr. A's report, said didn't meet the criteria, but at hearing, she said no, he has PTSD, and then the comp judge says it's through the day of the hearing. And so explain to me how that works.
Absolutely. The reason for that, Your Honor, is because at the date or when Dr. Alek-Novichess evaluated Mr. Peterson and issued her report, she was using the DSM-5. At the hearing, she used the DSM-5 TR, which included that additional language about how criteria F should be interpreted. So even though the actual verbiage of the criteria did not change, the diagnostic features section goes through each and every criteria and explains to practitioners how they should be using and applying that criteria. The lifetime diagnosis was added. And so using that, looking at that, Dr. Alek-Novichess amended what she said in her report during her hearing testimony because she needed to use the most recent version of the DSM, the DSM-5 TR, and the DSM-5 TR added that language, which allows for that lifetime diagnosis, meaning it's not perpetual, but the person does not have to meet B, C, D, and E in the 30 days prior to the evaluation. They do have to meet that at some point, but as long as there's ongoing impairment, the diagnosis remains PTSD. And what's happening here is the legislature, it defined PTSD as what is set forth in the most recent DSM. They did that intentionally. They didn't want to have all these modifications to the statute every single time, the research changed on PTSD. They wanted us to be up to date with the law. And so this standard for PTSD is by definition going to change. It's going to change every time we have a DSM. And that's a good thing because as the research evolves, so should the law. And that's what's happening here.
And then try to explain to me, because if we follow Smith, as Judge Quinn said, we're not supposed to read it, but we obviously have it. And I've looked at the difference between DSM-5, DSM-5 TR, and the change in the lifetime. Other than adding lifetime, I can't tell the difference between the diagnosis of PTSD, other than adding the verbiage, the lifetime bit, because it looks the same to me.
And I am no licensed psychologist, but we can rely on Dr. Alek-Novichess's testimony here. The criteria, and Dr. Young's, frankly, the criteria did not change between the DSM-5 and the DSM-5 TR. Everyone agrees on that. But what did change, if you page after the criteria, is that diagnostic feature section. And this isn't just notes or footnotes about the criteria. Really important stuff goes in there, and it tells the practitioners how they should be using that criteria. It goes into detail about that. So
okay, I understand, but I'm just looking at the time. It's like the 30 days preceding and this, and
okay.
it's basically saying if you have the 30 days preceding, then you still meet the lifetime. So I'm not seeing any real. I understand the criteria is there and being met, but at some point in time, but it's not like, okay, you've now had it for a year or something like that, and based upon a year-long, we're going to make it lifetime. I just don't see that. Can you help me out?
So what was added is on page 308 of the DSM-5 TR, which I have in front of me here. And it's the very last paragraph going on to page 309. And it is in the exhibits as well, bait stamp 0363. What was added was a differentiation between a current diagnosis, which is that second sentence there. For a current diagnosis of PTSD, criteria B, C, D, and E must all be met for more than 1 month for at least the past month. So we're looking at the 30 days prior to the evaluation of the respective psychologists in this case. And then it goes on to add, in this new language, for a lifetime diagnosis of PTSD, there must be a period of time lasting more than 1 month during which criteria B, C, D, and E have all been met for the same 1 month period of time. The difference there is that it doesn't have to be the 30 days preceding the evaluation anymore, at least for B, C, D, and E, the symptom clusters. The other criteria are still intact. So for example, what I was talking about before with criteria G, that would still have to be met at the time of the evaluation because that was not included in here. Which is why that goes to my point that this is not a perpetual diagnosis, because if a person is not impaired in one or more areas, important areas of life, then they do not qualify for a PTSD diagnosis. Does that answer your question?
So if I'm following, so the amendment to Dr. A's opinion is, may not have had it, but looking back at the current version, the TR version, because it was met for the 30 days you follow in that lifetime, which makes the diagnosis current at the time that she was testifying on the day of hearing.
Yes. The important part is DSM-5 was used at the time of her report, and the DSM-5 TR was used during her testimony, Your Honor.
Yeah, I have a question. Is there any evidence that says that she did look at that 30-day period preceding the diagnosis?
That Dr. A did
Yeah,
that?
I didn't see that in her report. I'm wondering if you can enlighten
Yes.
me. Thanks.
There is evidence of that, Your Honor. She utilized what's called the CAPS-5, which is a structured interview, and she used what's called the 30-day version. Under the 30-day version, you are only allowed to ask questions about the symptoms that occurred within the 30 days prior to the evaluation. In addition to that, Dr. Alec Noviches conducted a clinical interview, and that is not a structured interview. That's where she goes through basically Mr. Peterson's entire background, including when his symptoms were the worst. And of course, she reviewed all of the records and reports in this case as well.
So then doesn't she need to administer a new testing?
I think ideally, there would have been a new evaluation issued before we tried this case, Your Honor. Unfortunately, here that did not happen. When in Mr. Peterson's case, we started out where the DSM-5 was the most recent version. Through the pendency of this case, that changed the DSM-5 TR. And in reviewing for the hearing, I thought that we needed to address the DSM-5 TR in order to move forward with the hearing, because I believe that's what the legislature requires us to do in 176.011.
Ms. Bierman, is the only difference between Mr. Peterson's case and the HERS case the TR version of the DSM?
I think it comes down to that, Your Honor, along with the fact that there is a current diagnosis of PTSD in this case, per the most recent version of the DSM, as diagnosed by a licensed psychologist. In HERS, there's no dispute, there was no current diagnosis of PTSD. Here we have that.
And I'm not asking you to recite the HERS medical records, but had the TR version been out, there could have been a diagnosis of PTSD. The cases are very similar, do you think?
So actually, no. And the reason for that is Mr. HERS did not meet, at least according to Dr. Slavic in her most recent, her second evaluation, he did not meet criteria G. And that was in the decision. And criteria G, that impairment, the clinically significant distress, that criteria would have had to have been met to have a diagnosis of PTSD. So Mr. HERS would not have qualified for a diagnosis of PTSD per the DSM-5 TR. And again, not a licensed psychologist, but I'm doing my best over here. And
I'm sorry, but didn't Dr. A in her report say your client didn't meet G?
so Dr. Alec Noviches in her
Report.
I understand.
Yeah.
In the CAPS 5, she did not get to criteria G or F because he did not meet a few of the
D and E,
criteria.
I think was, yeah.
And so she did not address that. But Your Honor, if you look on, I believe it's it's Bates 002, she does specifically address the fact that Mr. Peterson continued to have impairment in one or more areas, important areas of life. And she also testified to that in various points in her deposit, or excuse me, in her live testimony at hearing.
Ms. Bierman, I'm going to ask you the question that Judge Quinn asked Mr. Gabor. If we were to agree with Mr. Gabor and say, no, there is no such thing as a lifetime diagnosis, or if it's lifetime, it doesn't mean it's permanent. Because Judge Daly did not address the issue of the consequential injury, would it be appropriate for this court to remand to Judge Daly for finding on a consequential?
Your Honor, I don't think that Judge Daly addressed the issue of consequential injury because he found that there was a current diagnosis of PTSD. So
Right, and that's what I'm asking. If we were to do something with that, do you feel that it would be appropriate then for Judge Daly to make a finding on consequential injury?
I do, Your Honor.
I'm sorry, have you addressed the penalty issue?
I have not, but I certainly can do that. The penalty issue, along with the other issues in this case, are squarely fact questions for the judge to make. So first, the standard that should be applied to all these issues should be the substantial evidence standard of review. And this court has held previously in Maxfield v. Stremmel that whether a penalty is appropriate is within the sound discretion of the trial judge. Here, the notice of primary liability determination cited to some pre-existing personal mental health conditions, of which there is absolutely no evidence of this in the record, or if Minneapolis would have conducted an investigation of this claim, it would have readily found that this was not in fact the case. They had access to not one but two pre-employment psychological evaluations that Mr. Peterson underwent at the beginning of his career, both of which showed that he was in good mental health prior to his career and recommended him for duty. They, of course, had full access to the very traumatic incidents that he was involved in, particularly the one in 2002, in which a suspect was killed in custody. And they know that he was referred by them to a a fitness for duty evaluation. And that's what led to him seeking treatment at that period of time. So they had all of this information in their own records. So had they conducted any type of investigation, that would have been clear to them. And in this case, there's absolutely no evidence at any point presented that Mr. Peterson and his mental health was affected by anything except for the really significant traumas that he experienced at work. This is the exact case that where penalties should be awarded.
And again, penalties were only awarded up to the time of the issuance of Dr. Young's report, and that provided the colorable defense. And Judge Daly denied penalties after that date.
That is my understanding, Your Honor.
And again, as far as you know, there was no amendment, as Judge Quinn asked, as to the NOPLD, taking out that defense, and at no time does it ever appear that Mr. Peterson was paid any benefits up. It doesn't sound like he's been paid yet. So is that correct?
That's correct, Your Honor. They never amended the notice of primary liability determination. Mr. Peterson was not paid any benefits until we tried this case. He was paid a certain period of benefits for the initial period up and until Dr. Young's report date. So he has been paid some wage loss benefits to date, and the rest is obviously pending as we work through this appeal process.
Say that again.
Yes.
He was paid,
Oh, excuse me. That was after the trial. So
after the trial.
So
Okay.
nothing prior to us trying the case was paid on Mr. Peterson's case. It remained a denied claim.
Okay, and what was he paid after the trial?
So after the trial, and the dates probably will not be perfect, but from the date of injury through the date of Dr. Young's report, the city of Minneapolis issued wage loss payments, and they should have issued payment for some of those medical bills as well.
I have a question regarding the penalty claim, and the colorable defense? Because we first get Dr. Young's report, right? So that's in what, March of 2022?
Yes,
And then
Judge.
2 months later, 3 months, June of 2022, we get Dr. A's report, and it says no PTSD. So basically now there are 2 experts who say no PTSD. So is that not a colorable defense at that point?
Judge, Dr. Aleknovich's report was based on the DSM-5, as was Dr. Young's, instead of the DSM-5 TR. Under the DSM-5 TR, I don't believe that that's a colorable defense. However, to answer your question, I do believe that for purposes of a notice of primary liability determination, Dr. Young's report would have served at that point as a defense, and that's what Judge Daly did here. He only awarded the penalties through the date of Dr. Young's report.
Thank you.
I do have another question on the penalties. All of these PTSD cases seem to blaze a new legal trail because it's still relatively new. And in the Juntanen decision, it was made clear, hey, you, the employer, if you get a claim for PTSD, you have to present substantial factors as to why you would deny it. Otherwise, you got to start paying it because you, in a presumption case for people like your client, police officers and so forth. But at the time of the denial that was made here, which I think predates Juntanen, or was right around the time of Juntanen, we have a city that doesn't know exactly what they're supposed to be doing. There might be more guidelines now, but at the time they did that, they didn't know exactly what they were to be doing. Is penalties fair? I mean, I get your argument why penalties were awarded, and they're good arguments, but when we have an employer that has no real guidance on what they should and shouldn't do yet.
Judge, in this case, the notice of primary liability determination did refer to substantial factors. I do believe that they had adequate notice of the fact that Mr. Peterson was an active duty police officer that was diagnosed with PTSD per the diagnosis of a licensed psychologist here. They know the presumption applies. And instead of accepting liability for this claim, admitting this claim, and paying Mr. Peterson while he's off of work seeking treatment, they chose to deny that claim instead and not conduct any type of investigation. There's no evidence that any investigation was completed. And if you review the notice of primary liability determination, which is an exhibit in this case, you'll see that there's not one thing specific to Mr. Peterson in that notice. It is generic, copy-pasted from person to person. They did not do an investigation here, and I do think that they had adequate notice on what they should be doing here in order to investigate the claim. And because this is a presumption case, even if he would have had a pre-existing condition 20 years ago, and he was able to work as a full-duty police officer in some of the most proactive units in the Minneapolis Police Department for those 2 decades, I think that they would be very hard-pressed to show substantial factors to rebut the presumption based on that treatment, even if it had been personal in nature.
I do have one other question. This is more out of morbid curiosity than anything else. Your client was subjected to all of these various traumas. Some of them were physical traumas.
Yeah.
I know you didn't try this case this way, but why not physical, mental?
In this case, Your Honor, he's not seeking ongoing treatment for those physical injuries. Most of them were closed-ended injuries, and he went back to work afterward. The injury here for Mr. Peterson is in the nature of post-traumatic stress disorder. Perhaps there could have been some other ways to approach this case, but when I'm looking at it, that primary injury is absolutely post-traumatic stress disorder. It's what he's consistently treated for. It's what his restrictions are based upon, and it's what caused the end to Mr. Peterson's law enforcement career, which is why that is the injury that we sought here.
Anyone else have any other questions? All right, thank you, Ms. Bierman. Also enlightening. All right, so the case is now closed, or the record is now closed. The decision will be issued within 90 days. Thank you both. This was very, very helpful, I believe. We're adjourned.
All right. Thank you.